Legal Center versus Scott. Mr. Cuenin.
Thank you.
Yes, sir.
May it please the court. The plaintiff organizations that sued the Texas Secretary of State for information under the NVRA failed to prove they suffered any injury in fact. They lack standing. To get to that conclusion.
What does that argument do to FOIA?
Well,
Freedom of Information Act.
So the argument that we're making in this case is particular to this context of the downstream consequences failure under the NVRA claim.
Right.
As far as what that would look like in practice, the cases that are discussed in the opinion that became TransUnion, the downstream consequences language came from an opinion by Judge Katsas. He was sitting by designation on the 11th Circuit, but it was his opinion, the court noted this, referencing the public citizen cases and a case called Akins. In those, what those look like is an example of what proving downstream consequences looks like for this type of information. So, for example, in public citizen...
So you're talking about the facts of public citizen, right?
Facts and... Factually, but...
But if you look at what the decision actually says, that's not how public citizen is analyzed. Right? Public citizen, I think, has some pretty broad language about basically once you prove that you've made a request and the request has been denied, you have standing.
So I understand that that is one view of what happened in that case. My suggestion would be that...
It's a quote from the opinion.
Well, there have been courts since then. For example, the 10th Circuit Court case that we cited, a recent one, Judge Katsas' opinion, they point out that there's no need to... I'm sorry, let me take a step back. They described that in those cases there was a downstream consequence. It's just simply the ability to participate more effectively in the judicial selection process. In Akins, that it would help the voters to evaluate candidates for public office. It's really not a burdensome requirement. And standing never has to do with the quantity of the evidence.
Pardon me for interrupting again, but I'll just read what I'm thinking about in public citizen and you can respond accordingly. Page 440 of the opinion of the court, and I believe nobody disagrees with this proposition in public citizen. I know there's a separate writing, but not on the standing issue. So as far as I'm concerned, public citizen unanimously says the following. Our decisions, this is page 449. Our decisions interpreting the Freedom of Information Act have never suggested that those requesting information under it need show more than that they sought and were denied specific agency records. Is that no longer the law after TransUnion? Is that sort of your point?
Well, not quite. My point is that those are examples of what one would show and that it's been described. For example, in that 10th Circuit case, a similar requirement of doing something downstream with the information, as Judge Katz has described it, consequential harms from the failure to disclose the contested information. And it's not, again, not particularly burdensome. It's just you would expect to see, for example, a voter who is claiming, I'm having trouble participating in voting process, an affidavit, something like that you could actually test. Here, the plaintiffs, it's a little hard to understand exactly what they're claiming, but it's in the nature of an organizational injury, it seems now, and they are asserting in attorney argument, or in the briefs at least, a non-concrete sort of speculative interest that out there in the world there may exist third parties who have these interests, but they haven't tied it back to themselves in any concrete way under City of Kyle, for example, which the opposing parties haven't even responded to in the briefing.
For what it's worth, it's fine if you don't want to deal with it, but I'm not sure you've responded to my question about this sentence. It says, we, the Supreme Court, have never interpreted FOIA as requiring anything more than a request for records that was denied. That's it. So I thought you were going to say that TransUnion makes that no longer the law. And I think you actually may have an argument, but I think it's worth acknowledging that this is a big change in FOIA.
As I see it, there's one way to look at that and say that's a big change in the law. There's another way to say that's what the law has always required, and that when courts have looked at it since then, for example, that 10th Circuit case and others, they've said that what is happening in public citizen in Akins is an example of downstream consequences, and they're tied to...
But again, we agree, though, that sentence that I just read does not in any way require downstream consequences. In fact, quite the opposite. It specifically says it doesn't require downstream consequences.
I mean, I may just have to disagree that that's the best reading of that in practice under the context of that case. But I understand that that is a view of those cases. I just don't think that it garnered majority support in TransUnion, for example, and cases applying it since then.
I think you're right. It definitely was abrogated in TransUnion. I think that's sort of how I see it, but go ahead.
Well, and if that's the case, I mean, I think we get to the same result. Either it's abrogated or that's just what the requirement had been. And I apologize for confusion on that.
It just seems to have dramatic consequences for a lot of areas of law besides NVRA and
and again,
fair credit and that sort of thing.
I'm certainly sensitive to the concern, but I think if we kind of unpack and take a step back, what it might look like. Let's take the NVRA, for example, since that's the context of this case. Not particularly burdensome. You would expect to see some sort of affidavits or testimony, somebody explaining, if it's a voter, for example, they may say, I'm concerned about whether I should go vote because I don't know if, am I going to get in trouble or something like that. I'm probably not thinking through all the implications of that hypothetical, but that's an example of something a judge could test. Or maybe it's a political candidate who's saying that a group of voters who I think might vote for me, these might be people who are concerned about the voter list maintenance and tie that consequential harm that way. So it's not that it's a sea change. I just think that
Well, it's a sea change in this sense. I mean, again, I'm sorry to keep harping on the FOIA, but this will be my last question, at least on FOIA. There's a saying in the FOIA world that every citizen has, the right to know what their government is doing. They don't have to prove the need to know. And it strikes me that under TransUnion, that is now completely flipped on its head. You now have to prove the need. Not just the need, the injury if you don't get it.
I think the way Your Honor phrased the question maybe tracks kind of colloquially what people think of when they think of what this when they say there's a right to know. Maybe just thinking of that in that colloquial phrase maybe is not going to survive moving forward, but just putting pen to paper and actually writing out. Maybe, for example, it's a journalist that's writing a story. They're going to exercise their First Amendment right. So I think as this goes forward in time.
So I'm sorry, you're saying a journalist could survive TransUnion?
Again, I've not thought all of this through. I'm just thinking.
If you say a journalist can do it, then I'm not sure why Campaign Legal Center can't. They're both the same interest in governance.
And I think this is where it gets very murky in this case because I'd have to talk in terms of speculation. We don't have that type of record where you would actually be able to test what they're saying their consequential harm is. I think maybe this case looks different if you have an organization. Think of City of Kyle versus NAACP problem there, right? You've got an organization, and they're not really explaining how they themselves are injured in any way. It's not like, for example, saying we're having to do extra voter contact efforts because we have to contact more people and explain to them what's going on. And if we had the information, we wouldn't have to do that. Just to give an example, maybe this case looks different. We just don't have that, and I'd really have to be speculating about that given the total absence of standing evidence. And I want to also, maybe a final point on standing, I want to note that in the plaintiff organization's briefing, they do describe, sort of for the first time, this is not in the trial record at all, but this notion that there was a settlement in 2019. But I want to note that these plaintiff organizations are not party to that settlement, and they describe the parties to that settlement as former clients at page 12 of their brief. So if the plaintiffs mean to suggest, and again, it's not clear exactly what they mean, but if they mean to suggest that there exists in the world some group of people who may have some sort of third-party injury, they've not made the link back from those other people to themselves, these organizations.
Counsel, help me a minute if you could. Is the Texas Secretary of State's office the custodian of like the statewide election voter database, the list of all the voters around the state? I mean,
it generally tracks my
well, I mean, I'm asking, in Mississippi, that's the case. I mean, we call it the Statewide Election Management System, the SIMS. So we've got the overall database in the Secretary of State's office. And my question, I guess, is, assuming that's true, who can request reports or subsets or data out of that database?
To be perfectly candid, Joseph Wilson, I don't know the answer to all of that. As far as maintaining the database, It gets maybe a little bit complicated in this case because it's sort of split up the way that the records that we're talking about here. Part of the actions and decisions are being made at the local election official level.
The local elections officials have access to the database. I mean, again, I'm going by Mississippi experience. The Secretary of State's office has access to the overall statewide database. And of course, here you've got Department of Public Safety or the driver's license people who are collecting data originally, and then there's a cross-check. That's how this list of 12,000 possible matches was generated, right?
Yes,
but all of that's folded into a statewide election database or a voter database, right? Or do you know?
There's probably some nuance to that I'm not aware of. I want to be cautious.
Well, the reason I don't think it's a nuance, because I guess my question is, and if you can't answer it, that's fair enough, can people go to the Secretary of State's office, people, the plaintiffs or anybody, and say, I'd like to get the 5th Congressional District registered voters or voters who voted in the last primaries, or however you want to slice it and dice it. Can I get a download of that?
Maybe this is too general of an answer, but I'll try my best. I mean, there's obviously some set of this voter data that is public. It's not that the entire nature of everything in every database belonging to the Secretary of State is confidential. This is a specific argument, and I think we turn to the merits, but it's a combination of things that is non-public, right? This is the cross-checking with the voters who at one point registered to vote, and then at a subsequent point in time indicated to the Department of Public Safety, which is the entity that maintains the driver's licenses in Texas, and I'm not sure who does it in Mississippi.
Voter form, you can basically check, I'm not a citizen, and you can also check, but I'd like to register to vote.
Well, and so the subset we're talking about here, it's limited in nature in that the point in time matters, right? Because it's someone who at point A earlier would have said, I am registering to vote, and then later in time indicated they had lawful presence but not U.S. citizenship. And this is uncontroverted in the record, by the way, this is the affidavit from Mr. Ingram, I'm looking at 565 to 567, explaining how this works. There's a process wherein the information is investigated at the county level to see, someone's ineligible to be on voter lists. We're still waiting to come back from the counties to have all that information, to process it, to continue analyzing, and then to make the appropriate referral to the Texas Attorney General's office, for criminal prosecution.
Well, and I guess my next question along that, maybe perhaps it was a rabbit trail, was how much can people who want public information from the voter database, how much can you drill down and get specific things? And obviously the next question would be, could they get this information via some sort of public request?
Sure, and as far as I know, the answer is no. And I think the fact that my opposing counsel continues to litigate against the Texas Secretary of State says everything we need to know about whether this information is publicly available or not. It's not.
They were already checking some of this against the county records in Tarrant County and Travis County or something.
So Judge Jones is consistent with the way this statute and Mr. Ingram's affidavit lays out. There is a component of the ongoing criminal investigation that contemplates information needs to go out to the counties because the counties determine.
No, I thought the plaintiffs had already obtained some of this information from the county voter records.
So the record's a little bit murky on that. I understand their position to be, well, since we've contacted some counties, and those counties have given bits and pieces of information, therefore the secretary can't maintain any confidentiality at all.
The county registrar has the voter lists, right?
As just for the appropriate county and...
Yeah, for the county. It has the voter list for the county, and since most of the counties currently have voter registrars who are of the same party as that with which most of the plaintiffs are currently aligned, at least the big counties do, they can get that information, right?
And in theory, I suppose that's right as far as what the consequences of that is.
There may be 1,000 Jose Garcias who are registered to vote, but they could get a list that there were 1,000 Jose Garcias, right?
I think that tracks something that I think might be able to happen. But of course, the consequence of of that is, in this case, is that it's not just the names they need. They're trying to cross-reference it with the identification. That's the piece that matters. It's not things in isolation. And
Could they get the DPS records through the state FOIA or whatever?
no, and this is information that's separately, and I see my time has just expired.
Go ahead and answer this.
We've got a separate argument under the Driver's Privacy Protection Act that raises additional concerns about that type of information as well, and we submit the district court erred.
All right, Ms. Danahy.
Good afternoon, Your Honors, and may it please the Court, Molly Danahy for the Plaintiff Appellees. The National Voter Registration Act requires states that choose to conduct federal elections using advanced voter registration to maintain and produce for public inspection documents related to their list maintenance activities. Texas is such a state, and this public disclosure provision serves an important purpose in allowing the public to monitor not just whether states are complying with their obligations to ensure that eligible voters remain on the rolls, but also to ensure with their obligations to conduct list maintenance and keep clean and accurate rolls. The defendant, Secretary of State John Scott, engaged in quintessential list maintenance activity when he proceeded with the program that's at issue here. And to explain, Judge Wilson, a little bit about how the Texas statewide database works, the Secretary of State does maintain a statewide database of all registered voters in the state of Texas, and I believe that that's called the TEAMS database. Any person can request any part or subset of that list. There's limited purposes that they can use that list for. For example, I believe it can't be used for commercial purposes, but any person can submit a request for that list or a subset of that list and obtain precisely the information that the plaintiffs are seeking to obtain here.
Have you done that?
We have not, because what it is issue here is a subset of this list that cannot be disaggregated from the wider Texas registration database without the Secretary telling us who he identified through the matching program and giving us the identities.
So tell me your entitlement to that information, that particular information, since what you're saying is this would not otherwise be available.
Well, the name and voter ID information is, which are the two pieces of information that the state still has not provided to us, is available under a request for some geographic or full copy of the Texas voter registration list. But what is not available is a subset of the list that was created through the matching program with DPS. We are entitled to that under the NVRA's public disclosure provision because the list was created for the purpose of list maintenance. And there's no real dispute that that's the case. I know the Secretary...
So anybody's entitled to that information?
Correct, Your Honor. Anyone that wants to make a request for that information under the NVRA would be able to obtain it.
Well, are they able to obtain it when it's already done and completed, or on an ongoing, could you ask for a 24-hour refresh every time they cancel somebody from the rolls who they got a death certificate for?
Well, Your Honor, we've asked here, the plaintiffs have asked here for a small subset, I think it's 11,000 some odd records that were identified at the beginning of this program. And there's no limit under the NVRA on how many records requests you could submit. But what we're looking for here is a very targeted list of voters that were identified at the initial outset of relaunching this list matching program against the Department of Public Safety's records.
Well, I mean, technically what the statute says is make available all records concerning the implementation of programs and activities, except to the extent that they relate to declining to register to vote or the identity of a voter registration agency. But as you know, implementation of programs and activities doesn't necessarily mean the entire voter list, does it?
No, and we're not asking.
It's more like, what do you call it, methods and sources and methods.
Well, I think the term records under the NVRA is not limited to sources and methods. It certainly would encompass that, but it also encompasses records related to list maintenance activities. That's a fairly broad term, and courts have uniformly found, I believe, that it extends to the types of records we're looking for here. It, for example, extends to voter registration forms that contain all of the information that we're seeking here.
So let's talk about standing. We talked about that a little bit. Opposite. Where's your injury? And what do you have to show? Is it simply that you asked for the information and they said, no, you can't have it, or is more required?
Yes, Your Honor. Under Akins and Public Citizen, as the Supreme Court affirmed just recently in Spokio in 2016, all that we're required to show under a public disclosure provision law to show injury is that we requested the information pursuant to a public disclosure provision and that we were denied that information. And TransUnion does not change that. TransUnion and the cases that the court cited in that case, as well as the 10th Circuit case, I believe it's Lawfer, relied on by the other side, they all involve injuries to plaintiffs who, at the time they brought suit, had all the information that they had requested. They do not involve injuries like we are facing today or that we're discussing today, where the plaintiff has sought information and has been denied that information and continues to be denied that information at the time of suit.
So I would agree with you about the state of the law before TransUnion. What I'm concerned about is TransUnion seems to abrogate it. You already talked about that one paragraph that I think we're all focused on in TransUnion. I just look at the last sentence. An asserted informational injury that causes no adverse effects cannot satisfy Article 3.
Yes, Your Honor, TransUnion does say that very explicitly, but it says that immediately after explaining that it is not applying the Akins Public Citizen line of cases because the law at issue in TransUnion was not a public disclosure provision. And so...
But my concern is this paragraph seems to be providing multiple reasons why the court is rejecting, I guess it's the United States' argument in TransUnion.
Correct. I believe our position is that you get to TransUnion when you have the information and you are seeking, for example, damages, which the plaintiffs in the class action in TransUnion were doing, which the plaintiff in, I think it's Trishelle, the 11th Circuit case, and I believe in the Lawfer case as well. All of those cases involved plaintiffs seeking damages for misleading information that was provided to them. And therefore, the court correctly found, or very explicitly at least found, that a plaintiff in that situation would have to provide proof of downstream consequences. When the information is not in the hands of the plaintiff, which is the case here, the downstream consequence is that they do not have the information that Congress has given them a right to obtain.
But that sounds like that sounds like informational injury.
Yes.
And the Supreme Court is saying an asserted informational injury does not satisfy Article 3 in the absence of adverse effects, namely this downstream consequences stuff. So I think you would win under Public Citizen. I'm not sure you win under TransUnion.
Well, Your Honor, I do
not win, but standing.
I do think that it would be very odd for the Supreme Court to have created such a massive sea change, as you yourself referenced, in the law surrounding public disclosure provisions, specifically like FOIA, like the NVRA's public disclosure provision, immediately after explaining that it was not, in fact, applying that standard, and to do so sort of I'm
sure you're aware I'm not the only one to have this concern about TransUnion. I think Professor Chemerinsky has voiced this theory of TransUnion as well, and
yes, Your Honor.
I'm really not sure what the response is, to be honest.
Well, I would say we think you can square TransUnion with Public Citizen and Akins in the way that I've suggested, which is that if the plaintiff still does not have the information that they're seeking, that is inherently a downstream consequence of being denied the information. That said, there is
what
sufficient...
What is informational injury? Because this will be my last question. I don't mean to occupy your time, but to my mind, informational injury means, according to the Supreme Court, you want information, you're not able to get it. Hence, informational injury. If I understand that term correctly, the Supreme Court is literally saying that does not satisfy Article 3 without something else on top of that.
I think Your Honor is correct in describing the informational injury that arises out of a public disclosure requirement or a law requiring disclosure of public information. That was not the harm. None of the cases relied on by TransUnion or cited by the plaintiffs involved the denial of information. And so it was a different type of informational injury, and I think that is where we would square. There's an informational injury when you are denied access.
Are you saying that today's case is not an informational injury case?
No, I'm saying today's case is an informational injury case under
I agree.
Public Citizen and Aikens, as affirmed in Spokio. The informational injury being discussed in TransUnion is about receiving misleading information, not an omission or not a denial of information that you're obligated to attend.
I don't know that that's the best way to read that paragraph, because the beginning of the paragraph talks about the United States as amicus theory, this is where it's all coming from, talking about concrete informational injury under these courts' precedents, this court's precedents, Supreme Court, Aikens, Public Citizen. I think it's using informational injury in the exact same way that Public Citizen does.
Well, Your Honor, I would disagree because I believe right after that it says that the plaintiffs here have not asserted an injury under a public disclosure provision.
Counsel, so we've got to decide what that means. You agree at least that if this last sentence in the paragraph we're talking about in TransUnion applies, you haven't had any adverse effect that would satisfy standing?
No, Your Honor, and I think the record supports that we have suffered downstream consequences.
What are those exactly?
Those are that because we have been denied this information, we're unable to evaluate whether our former clients, to whom we still owe a duty who were members of the settlement agreement in 2019, have claims that they may bring to either enforce that settlement agreement.
So they're former clients, they're parties to this 2019 settlement agreement, plaintiffs here are not.
The plaintiffs here negotiated the settlement agreement on behalf of the 2019 plaintiffs with the state.
Who were the 2019 plaintiffs?
The 2019 plaintiffs were a number of affected Texas voters, so namely naturalized citizens who were eligible to vote and had registered when they were eligible.
And I didn't recall that you were saying that you're still representing. How do those people have any interest in this at all anymore?
Well,
Do they think they're being purged again?
Your Honor, we don't know because we don't have the list of
Well,
individuals.
then why are you any different than an ambulance-chasing lawyer who wants to go into the police records and say, tell us exactly where this accident is, going on right now, where you're working this collision so that we can go up and give them our card?
Well, Your Honor, the 2019 plaintiffs specifically reserved rights to challenge, in particular, to enforce the settlement in particular.
I guess my point is, 2 points. The first one is, I don't believe Judge Yackel ruled on that, right? He didn't really treat this as a continuation of the 2019 suit. This is not a motion to enforce a settlement agreement.
No, Your Honor, and the reason that it's not a motion to enforce the settlement is because in order to determine whether our
Because it's a
clients
new
have
case.
a claim to, I apologize, I did not mean to speak over you, but in order to determine whether our clients have a claim to enforce the settlement, we need the information from the Secretary of State.
Well, and that brings me to the other point here, which is, I thought I read something that suggested you had gone out and got, you being your side, whoever you are, went out and had coordinated with voter registration, county clerks in Tarrant County and some other county to get certain information relevant to your needs and inquiries.
Yes, Your Honor. The plaintiffs submitted public records requests to a number of counties, and they received responses from, I believe it's Tarrant, Travis, and Collin County. And those are in the record. They're attached to declarations, which are ROA 123 to 125 and ROA 126 to 127. And the spreadsheets themselves are at ROA 491 to 500, which is the Tarrant County spreadsheet. ROA 503 to 514 is the Travis County records, and ROA 516 to 523, which is the Collin County records. And as those declarations made clear, those spreadsheets that are in the record are redacted. The plaintiffs did that of their own volition before putting them on the public court record. but we'd be happy to provide unredacted versions to the court if it would assist you.
Well, so what information is not contained in those? So you think, I mean, are you just trying to get duplicate information?
No, Your Honor. Unfortunately, those are only a small subset of the overall 11,000 voters who are identified through the list maintenance program, and we're trying to evaluate the list maintenance program as a whole. And so just having a subset of those records doesn't allow us to identify, for example, whether whether we have the types of the 2019 plaintiffs have the types of claims that they reserved there, or whether there are other potential claims that they might bring to challenge this process.
Why did you redact the information if it's public record?
Well, Your Honor, we were acting in good faith because the state had challenged whether these documents should be produced publicly, and that was an issue before the court, and we thought it was in the best interest to maintain the privacy.
But setting aside the question of these former clients who are no longer clients, whether they have any sort of cognizable adverse effect or injury, I'm still struggling to see how the plaintiffs here have any adverse effect or cognizable injury. I mean, you know, when I represent clients, and their former clients in particular, I don't know that anything that might affect them one day or another lets me go into court and have standing myself.
Well, Your Honor, I think it's particularly tied to the settlement agreement because we represent...
But you're not parties to the settlement agreement, are you?
No, Your Honor, but we have a duty to our clients who are...
You said former clients, and now you're saying clients. Which are they?
To our former clients who are members of that settlement
And you
agreement.
should have litigated it that way, but you didn't.
Well, Your Honor,
Or at least
one of the reasons that
understand it that way.
we didn't... I apologize. One of the reasons that we didn't litigate it that way is because we wanted to obtain the information from the Secretary of State through a very straightforward NVRA request to determine whether there was a claim before we brought suit. I think that is a very appropriate way to have gone about it under our duties as lawyers to the court. No, Your Honor.
I mean, because that's clearly not enough, right? Just to go out and find and seek plaintiffs. That's not enough of an adverse effect to give you standing.
No, Your Honor. I'm saying we sought the information to be able to advise our former clients about their rights under the settlement and to identify whether there are additional claims that those clients might bring to challenge the program. I don't believe that's...
They're
fishing
naturalized
expedition.
citizens as to whom there was a lawsuit filed and a settlement reached. That's out. They are no longer your clients. They are your total former clients unless you're going to seek to enforce the settlement.
Correct. I do want to
But
be
you
clear.
have-
I'm sorry. I
Go
do want to
ahead.
be clear that there were also organizational plaintiffs involved in the 2019 lawsuit and who are
Well, why can't they make this request then? I mean, I assume
They could.
no matter what we do in this case, and no matter
There's
what happens
nothing
on
that
remand.
prevents them from doing that, but that doesn't mean that we, as the plaintiffs here, do not have a right under the National Voter Registration Act to seek and obtain these records for the purposes of evaluating the Secretary of State's list maintenance activities as part of fulfilling our duty to our former clients about whether or not they have a claim to enforce the settlement. And I think that is the injury to
When I had clients, I didn't have much time to worry about my former clients and what their interests might be on a given day-to-day basis. That's interesting. I mean, since we're speculating, what sort of injuries might you expect to find with regard to your former clients, whom I understand are citizens and registered to vote or whatever they may be? So what do you hope to find, given that they presumably wouldn't be checking, they wouldn't be within the population of this identified 12,000, would they? Or
We don't know, and the reason
No,
that
we
we don't
don't.
know is because the way that the list maintenance matching program works is it looks at records that, it takes the entire voter registration database and
What I don't understand is that even if the secretary uncovers a certain number of people that it believes may be illegally registered to vote, they have to send out notice to those people, do they not?
yes.
They may also prosecute them criminally, but if any of your clients who have already settled with the state get such a notice, well, then maybe you have another lawsuit. But as it stands, your clients are all registered voters, And I wouldn't be at all surprised if there's some kind of tick or something in the database that said already handled.
Well, Your Honor, I don't think that captures the universe of voters who are members or otherwise affiliated with the organizational clients in that case.
Well, I'm sorry, but you haven't said anything. We never heard a word about organizational clients before.
Well, I believe if you look at the settlement agreement, which is in the record, it lists all of the plaintiffs in that.
But you're not suing on the settlement agreement.
No, we are suing on behalf of the attorneys who represented the clients in that settlement agreement and the civic organizations that bring this kind of litigation on a routine basis.
When have you ever heard of a case? I mean, leave aside what the statute says and all that. Since when do attorneys have a right to stand up as interested citizens to say, I challenge that law, I demand that information? That turns the whole idea of case or controversy into a joke, doesn't it?
Well, Your Honor, I think the difference here is that we were talking about a public disclosure provision that gives the right to obtain this information to any member of the public. And what we're required to show here is that the denial of that information
That goes back
causes us some harm.
But it doesn't cause people harm because they are lawyers who are looking for a case to file.
Well,
that cannot be constitutional.
Well, Your Honor, my colleague on the other side explained that the interest at stake in Aikens and in Public Citizen, the so-called downstream consequences there were the, I believe it was the plaintiff's interest in participating in the electoral process and in evaluating the judicial selection process. And that's exactly what our organizations are trying to do here, is evaluate a process engaged in by the Secretary of State that they have some interest in. And we clearly have some interest in that process because we represented clients who sued to stop the prior iteration of this program. We continue to have an ongoing obligation to our former clients, in part because of the settlement agreement, which reserved claims that allow our former clients, including the organizational plaintiffs, to challenge the program if it is in violation of...
I assume the difference that's going to be drawn for us is in Public Citizen, it's about Public Citizen itself and Washington Legal Foundation itself wanting to be actively involved in judicial selection or whatever the issues were in that case. Whereas here, is it Campaign Legal Center itself that's concerned about voting, or is it the voters who are concerned about voting and you have an interest, obviously, as fellow voters, fellow citizens, but it's not the same direct personal interest. It's really an interest that every person in Texas would theoretically have.
Well, Campaign Legal Center has the same interest as any person who is seeking, or any of the organizational plaintiffs in this case, would have the same interest as any person seeking records under the NVRA.
Right.
And if TransUnion requires that we show some slightly more particularized interest, then I think we have done that here in the same way that the plaintiffs did in Aikens or Public Citizen, by demonstrating that we have a particular interest in the Secretary's process.
I mean, I certainly understand what you're saying, and it's a bit of a conundrum, but at the same time, we've had a lot of voting cases, and whenever we have voting cases where we have MALDEF and the NAACP Legal Defense Fund and all these other groups, they always have plaintiff voters who say, this is why this law impairs my interest. You're not saying that at all. What you're saying is, I'm this organization, and I need to find out whether I can find some plaintiffs to file a lawsuit about.
Well, Your Honor, I think the right to vote is both an individual and associational right, and so when you're talking about cases that are challenging a law based on its impingement on the fundamental right to vote, that would be why you are seeing those types of plaintiffs. Here, what we're talking about is a statutory right to information under the NVRA, which is available to any person, and person includes organization. And so, again, under the direct line of precedent that controls informational standing under a public disclosure provision.
Suppose it were the policy of the Secretary of State never to purge these people from the voter rolls. Would your clients be interested in that?
I think there would be a claim there because the state does have an obligation under the list. Well, I think there would be a claim there for two reasons. One, there's no requirement that you show why you need those records, just that you've been denied. And two, many organizations do use the public disclosure provision to ensure that states are actually conducting list maintenance activities and are purging ineligible voters from the rolls. That is exactly the type of claim that's at issue here, that we're also seeking to make sure that eligible voters are not being removed from the rolls. Doesn't mean that our interest or our harm is any different from an organization that is suing because it wants to know if the state is actually purging people who are ineligible.
May I ask a couple more questions? Just real quickly. I just want to make sure I understand. So the 12,000, give or take, are possible matches that the Secretary of State generated by comparing records with the Department of Public Safety or the driver's license database, right?
Yes.
The Secretary of State then takes those possible matches, 12,000, and distributes them among the counties, various counties of Texas, right? Who in Texas actually purges voter rolls? Is it the Secretary of State or is it the local registrars?
I believe that it's the local registrars.
Okay, so the Secretary of State here just is sending these 12,000 possible matches to local elections officials for them to determine whether or not they are non-citizen voters, possible registrants, valid voters, whatever they may be, before any action is taken, right?
Yes.
And then I'm sorry?
I'm sorry, go ahead.
Well, and so then the next step would be that the local registrars would send out some sort of notification, is this you, or whatever it may be, to try to verify. We're talking about purging the voting rolls or maintaining the voting rolls versus any kind of criminal investigation that may be happening at the state level. But that's the voter roll maintenance is local.
Correct. The Secretary of State creates the superset of data, which is the match of the statewide list against the DPS, and then it sends to the local officials their subset of that data. So it would send Tarrant County the Tarrant County registered voters that matched the DPS records. And then the local election officials, and I believe this procedure is laid out in the record at ROA 571 to 573. The local election officials are authorized to look at their own records, look at other county records to determine whether they have evidence that the registered voter is in fact a U.S. citizen. If they do not have that, if they cannot find any kind of record evidence of that, then they may send a notice letter to the voter notifying them that they've been identified as a potential non-U.S. citizen, and the voter is then required to submit documentary proof of U.S. citizenship within 30 days, or they will be removed.
Thank you. Maybe apropos of nothing, but I wanted to make sure I understood how the process works. Thank you.
All right, thank you.
Thank you.
Mr. Cuenin?
Thank you, Your Honor. I'll try to keep my remarks brief. Two points, really. Just one on standing, one on the merits, starting with standing. The plaintiffs were the masters of their complaint, and I think the argument we've heard indicates a fairly clear intent to proceed under sort of a test case theory that they don't need to prove downstream consequences. I think that's not the law that they can proceed under, at least as of TransUnion, whether it's an abrogation or that is just the correct statement of what the law had been. Either way. We think more importantly, though, for this present discussion, what my opposing counsel indicated was that there was no precedent applying the argument we were making to what they term an informational injury and access to information type claim. That's not true. That Lawford case, the 10th Circuit, had to do with information under the ADA. And so I think the court should be concerned that accepting my opposing counsel's position would create a split with at least the 10th Circuit.
Well, but does the NVRA have a public disclosure right or public information right that is as broad as the plaintiffs portray it?
I'm not sure that it does. I mean, the language itself does not include any kind of noun that would make one understand that this is something that these particular plaintiffs are specifically entitled to. It's a question I haven't fully thought out, but as a matter of subject matter jurisdiction, I think it's for the court to consider, both parts of that. The statutory right, does it contain, is maybe Alexander versus Sandoval might call it rights-creating language, let's say. If we look at the make available type language, it's not quite there. Now, the other part of the standing arguments that were made today is they're just not in the record at all. They were proceeding under one theory on appeal for the first time, that these are they're having trouble with third-party potential clients or maybe their former clients. I don't really know what they are. It's not entirely clear to me. It just seems that not having to litigate on behalf of third parties seems like the inverse of a pocketbook injury. It seems like less work to do. So it's not immediately clear at all what the actual concrete de facto harm is in the real world.
What do you make of their, I take it, their alternative argument that factually this is quite akin to Public Citizen and Akins?
My first reaction is that arguments in favor of standing can be forfeited, and that's an example of forfeiture. They just made it from the podium for the first time today. And the second response, the second response, a substantive response, is that, again, I acknowledge that maybe, hypothetically, let's say you have affidavits from an organization who is engaged in their own advocacy about, let's say, judicial selection from Public Citizen. That's a different claim than saying, I'm a lawyer and there are people out in the world to litigate on behalf of. Now, if they want to make the different claim, if a party wants to make the different claim that their own advocacy is affected, maybe there's a way to write up that affidavit, but at least you have it in the record and a judge can look at it and test it. And that might be a different case, but it's not this case.
Okay, so you're saying, you're acknowledging then that there could be an analogy between cases like this and Public Citizen and Akins. It's just not substantiated by the record.
Well, it's not substantiated, and it also runs into a sort of almost like a City of Kyle NAACP problem, not quite, because on these facts, we've got plaintiffs who are saying they were, I think I heard, unable to evaluate whether former clients had claims. That can't be true under the world we exist in, which was in 2019, they very much brought claims on behalf of individuals.
Put aside the former client point, because I find that a bit vexing for the reasons Judge Jones said. But just the straight up, Public Citizen wants to participate, Washington Legal Foundation wants to participate in the debate over judges.
I understand.
Campaign Legal Center wants to participate in the debate about whether Texas is abrogating voting rights or not. What's the difference?
And maybe there is a way to write that affidavit and give it to a judge, have them consider.
Your point is just that they didn't. They failed as an evidentiary matter.
Right.
To prove that theory.
At a minimum, yes.
Okay. Well, that aside, let's say they had. Well, would you then concede, or?
Well,
I don't think there's a distinction.
No, it gets messy. I mean, there's some traceability concerns as well with the points that the other sides.
What's the traceability concern? They get the information, they get the advocate.
Well, maybe I misunderstood. It was advocating on behalf of third parties. It's not clear how much of their claim is based on third-party injury versus third-party rights. And I think it's just too far afield from what I could speculate from here. But
They just want to advocate as Campaign Legal Center and as ACLU and I forget who all the other. They want to talk about the policy of Texas and their theories about whether Texas is doing good things for voters or terrible things. Unlike, no different from Public Citizen.
And perhaps that is the type of, I see my time's expired. Could I finish my response? Thank you, Your Honor. Maybe that's the type of affidavit or testimony you would end up seeing in cases like these. We don't have that here because we don't. It requires, this case was litigated on a very different theory, and we've heard that today, and it requires dismissal. Now, it's without prejudice, but it does require dismissal under this court's precedent.
Thank you, sir. I need to mention something before we go into recess. In the, go ahead.
Thank you, Your Honor.
In the brief of Appellees, which I notice neither of, at least Ms. Danahy, didn't sign, there was a curious statement in the discussion of standing on page 20, talking about starting out that the court in TransUnion observed that the plaintiffs lacked standing because they did not identify any downstream consequences. But, and then the statement says, I'm quoting from page 20, quote, at no point, close quote, did the court, quote, suggest that it was changing the ellipsis inquiry, close quote, for standing for public disclosure law claims or, quote, overruling all a part of, close quote, Akins and Public Citizen and the district court and this court, quote, remain bound, close quote, by those precedents. The brief then cites our recent en banc decision, Cochran versus SEC. I thought, having a vague recollection of Cochran, what the heck does that have to do with an MVRA case? So we went to footnote 11 in Cochran, which says, at no point did the Elgin court say or suggest that it was changing the Thunder Basin inquiry or overruling all or part of Free Enterprise Fund, which is yet another reason we remain bound by Free Enterprise Fund. Now, as an artistic matter, I see that someone is trying to draw a relationship between the idea that a more recent Supreme Court case doesn't necessarily implicitly overrule others, but to quote it this way to the casual reader gives the very misleading opinion that the Cochran case stands for some proposition itself relevant to this case. And I know you didn't write the brief, Ms. Danahy, but whoever did write it shouldn't try that kind of artistic license in the future. And that's my how to write lesson for the day. But we will not hold it against the larger merits of your position. And we'll be in recess until 9 o'clock tomorrow morning.